May it please Your Lordship, I beg to mention item number 13, my lord. I'm appearing on behalf of the respondents, and I've already taken the consent of the petitioner, my lord.
13.
13, my lord.
Who's for the petitioner?
Mr. Chanda, they have informed him.
This is for
It's for hearing.
hearing. On prayer made by the respondent, Union of India, not objected to by petitioner. List this matter after 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 10 on behalf of respondent number 4 and 5.
Yes, who's appearing for the petitioner?
Zarika.
Yes. Who is he? Have you sought his consent?
Is all good. Pardon, Your Lordship.
I've not seen him.
So he was here. He had appeared before the division bench. Let the matter be called up.
Yes, Lordship. Lordship, similar prayer for item number 12, Board of Trustee. The petitioner, Your Lordship.
Why this? I think this matter has
On
been.
last occasion also, Your Lordship, the respondent, they didn't appear, they are not cooperating, so we pray for most time, Your Lordship.
Oh yes. Who's appearing for respondent?
Is Sir Jindal.
But why is he not here? Should
Is
we?
there in other court?
So let the matter be called up.
Lordship, actually my senior also is engaged with some personal difficulties, so let the matter come up after 2 weeks.
This is going on. We cannot just wait.
Short time may be given, Your Lordship, it's fine.
On prayer made by the petitioner, this matter after 2 weeks. However, it is made clear that no more further adjournment will be given in this matter.
Much obliged, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 22.
Your fault?
The petitioner. And I'm appearing on behalf of the respondent, my lord. No objection.
On prayer made by the petitioner, list this matter after 3 weeks.
Highly obliged.
On daily cost list, item number 1.
Yes, who's for petitioner?
Lordship, I'm for petitioner, Lordship. Lordship, the respondent 3 and 5, last order they are supposed to file affidavit, Lordship. They haven't filed.
Lordship, I'm under the instruction of Peacekeeper Charge, respondent number 3, 4 and 5. We need 2 weeks time.
The issue is only with regard to notification.
Notification, Lordship.
So what? Facts are not.
The repetition.
Basically, facts are not in dispute here.
But there are certain paragraphs which are some allegations against the what you call the Provident Fund. So maybe they want to.
Provident Fund is a respondent number
3, 4 and 5.
3, 4, and 5. Then a counsel for the respondent 3, 4 and 5 respectively has sought for some more time to file the counter affidavit. On prayer made, the same is allowed. This is matter after 2 weeks.
Item
Item number 2.
May it please Your Lordship, I humbly pray that 2 weeks' time may be granted in order to file a counter affidavit in this matter, my lord.
Counter affidavit?
Rejoinder.
The respondents have filed
Yes, Your Lordship.
all the respondents.
Your Lordship, the state has filed, Your Lordship.
Is there any private respondent here? Is it that we bridge matter?
Yes, Your Lordship. Toll gate.
Toll gate, sorry. Yes, I think the respondents are all state respondents. So you have filed your counter, yes?
Yes, Your Lordship, we've already filed.
And you have to file the
Rejoinder, my lord.
The legal counsel for the petitioner has submitted that the rejoinder to the counter affidavit filed by the state respondent could not be filed today and has sought for some time in this regard. As prayed for, seems allowed. Let the rejoinder be filed within the next date fix. This is the same after 2 weeks.
Obliged, Lordship.
Item number 3.
Please, Your Lordship. I was a little under the weather this weekend, my lord, so I haven't had a chance to prepare this matter. May I just pray for it to be come up tomorrow, my lords? It's for a day's Passover.
As prayed for by the Leonard Senior G. You're a Senior G, Mr.
Yes, here I'm appearing for the MTDC.
Oh, yeah. Leonard Counsel for the respondent MTDC. This is matter tomorrow.
Of course. Highly obliged.
So we'll hear tomorrow.
Item number 9.
My Lord has passed an order on 18th April 23, my Lord, whereby petitioner was given a liberty to file an application before the authority concerned to get the proceeding of the security force court, my Lord. That petition we have already filed, my Lord. So we are yet to receive the copy of that security force court, my Lord, which is vital in this matter, since the proceeding is by which the petitioner was dismissed from service. So that proceeding is...
Yes.
Yes, my lord. We are awaiting instructions regarding that, whether we have to serve them or the department will be serving them directly, my lord.
Mr. Arjan and counsel for the petitioner has submitted that on being directed by this court, he had applied for copies of the inquiry report.
no, my Lord. It's a summary security force court proceeding.
Summary security force court proceeding, which according to the learned counsel is vital to his case. However, till date, the authorities concerned have not supplied the same to him. Mr. Leonard Counsel appearing for the Respondent Union of India has also submitted that no instructions have been received in this regard as far as the application of the petitioner is concerned. Application for the copy of the said to force security force report, inquiry report. Is it called inquiry report?
No, my Lord. It's a SSFC proceeding, my Lord.
Proceedings.
Proceeding.
On prayer made by the party, this matter to 2 weeks. By the time I think you'll get some.
Definitely, my Lord. Highly obliged.
Item number 10.
I'm back for some more time, Your Lordship, for the hearing. I pray for some more time, Your Lordship, though the conducting counsel is out of station.
Yes.
Respondent number 4 and 5.
Your petitioner.
Yes, sir.
Any objection?
No objections.
2016 matter.
Yes, Your Lordship.
On prayer made by the on behalf of the learned counsel for the respondent number 4 and 5. Not objected to by petitioner. Matter is adjourned. This is the after 2 weeks.
Much of it. Item number 11.
My lord, is a NOCMA matter. Well, this honorable court has heard the matter. And my lord, on the last occasion, my friend has sought some time for clarification. Here, my lord, if my lord goes to the order of both EM and CM, my lord, I fairly submit, my lord, that a fresh trial has to be conducted, my lord. Here, both the orders, my lord, is not as per the law. My lord, may kindly remand this matter.
Because the particular
Procedure was not followed.
official has passed an order in his own order against his own order.
Yes.
In appeal.
Yes, my lord. Yes, my lord.
When he was from EM
EM
to
CEM.
Okay.
Yes. My lord, my fair submission before this honorable court will be this, my lord. As I am an adjudicating authority, my lord, let both the order be set aside. Let status quo be maintained in the arcing, my lord. Otherwise, again, there will be problem, my lord, claim and counterclaim. And my lord, a deadline may be given. We'll conduct the trial within a specific period of time, my lord. Let both the parties appear, my lord.
That's fair enough. So you're appearing for all the respondents apart from the district council.
Respondent number 5, my lord. That ex parte order has been proceeded.
Okay. Respondent number 5 is the one that you have grievance against, isn't it? The one who has come in between.
Yes.
That is what he's saying.
5 and 4. 4 is.
I'm appearing for respondent number 4, 6, and 7, my lord.
Okay, but as far as 5 is concerned,
No, he is no longer appearing. Ex parte order has been proceeded.
okay, fine. Then we'll not. Then the merits will not be discussed. Look into.
Only both the order has to be set aside, my lord. EM and CEM.
No, CEM and that review.
Yes.
CEM order and
Review.
Where is the impugn order?
Impugn order is the last.
Page 73, my lord. The operative part. The order dated is 29/8/2016.
8.
29/8/2016. Page 73.
Okay, so this is the impugn order.
This is the impugn order and one more.
Starting from page 69. Starting from page 69. This one. This is the Annexure 9, page 69 also. That is the impugn order.
And one more order is there.
one order is Annexure 8, my lord. That is the type copy. This is
17/8/2015.
What is the page number?
Okay. Case number is GDC Revenue Appeal number.
Page number of
Page number.
You said one more order,
Page
isn't it?
58, my lord.
58, my lord.
That is the type copy.
No, so this is one order. 17/8/2015.
17, yes, my lord.
Yes.
So how is this order connected with the order 29/8?
This is the order, my lord, wherein he, in the capacity of EM, has already passed an order.
Okay.
Wherein he was elevated to the post of CM, but he has entertained.
Then subsequently he passed an order dated
against the respond number
29/8/2016 in his capacity as CEM.
CEM.
CM, my lord.
Necessary order may be passed, my lord.
Heard and the counsel for the petitioner, Mr. P.T. Sangwa. Also heard Mr. A.G. Mohan and counsel appearing for respondent 4, 6 and 7 respectively. Mr. S.D. Leonard standing counsel appearing for respondent 3,
1, 2 and 3.
1, 2 and 3 oblique GHADC respondent GHADC, that is 1, 2 and 3. Before the merits of this matter is to be looked into, the Leonard standing counsel for the respondent GHADC has fairly submitted that prima facie the impugn order dated 17/8/2015 annex 8 herein annex in the petition as annexure 8, as well as another impugn order dated
Annexure 9.
29/8/2016 annex as annexure 9 are not in the have been passed without any proper application of judicial mind, and the same are liable to be set aside and quashed. However, as to the grievance of the parties concerned, the Leonard Standing Council has submitted that the above mentioned impugn orders may be set aside and quashed, and necessary parties may be directed to appear before the competent authority.
Before the EM, my lord.
Before
Executive member.
One
before
matter
the
is sub judice, my lord. If that matter can be tagged on, or else there will be multiplicity
So they can file an application.
that you can
Let them file an application.
before the Contempt law. For the Leonard EM what?
In charge revenue.
In charge revenue to look into the grievance of the parties, to look into the dispute between the parties afresh. This submission has not been objected to by the learned counsel for the petitioner as well as the learned counsel for the respondent 4, 6 and 7 respectively. In view of the submission made, this court is also in agreement that the merits of the dispute between the parties has to be agitated before the proper forum, and the impugn order mentioned above not being proper in the strictest judicial sense, the same are liable to be set aside and quashed. Accordingly, the said order dated 17/8/2015 passed in GDC capital Mo dash REV oblique appeal number 17 A capital dot C of 2021. Between Srimati Nichi M. Marak appellant versus
Nogan.
Srimati Nogan Marak is hereby set aside and quashed. Next, similarly, the order dated 29/8/2016 passed in revenue REV dot number dot A oblique C capital 17 of 2011 in the case of Nogan Marak and others versus Nichi Marak and others, passed by the learned Chief Executive Member, Garo Hills District Council, Tura, is also hereby set aside and quashed. Next, resultantly, the petitioner, recently the parties who have set up the case in the first instance, because there are also other parties, no? They may come in between.
Let them file an application and tag those matter.
Accordingly, as last the resultantly resultantly in view of the above, the necessary parties are at liberty to approach the competent authority as to agitate their grievances. Petition disposal, no cost.
One more line will be required, my lord, that till the matter is decided by the EM,
yes, yes.
status quo has to be maintained
Oh, yes, sir.
in connection with the
Talk
arcing.
to as submitted till the matter is decided by the competent authority, that is the EM trading.
EM in charge land and revenue. Land and revenue.
EM in charge land revenue. Status quo is directed to be maintained by all concerned.
Both the parties.
By all concerned. It is also requested that the learned EM dispose of the matter within 6 months.
6 months will be.
6 months from the date of this order.
If not, then we will file an application for extension of time.
But I think it should be 6 months is good enough.
So because of evidence, that is the only problem.
Even
They have to
then,
lay
6
down the
months,
evidence.
Even then,
Yes,
it can be taken up. Can be taken up on a day-to-day basis for
file.
taking note of the court's order.
Yes, I will apprise them.
Petition disposal.
Hello.
Thank you.
Much blessed.
Item number 14.
May it please your lordship, I pray for some accommodation in this matter, my lord. If this matter may come up after 2 weeks, my lord.
School matter.
Yes, your lord.
The series of matter.
Yes.
14 to 20.
What is the difficulty?
Due to some personal difficulty, my lord, the conducting counsel is not able to take up the matter today, my lord.
Prayer is made on behalf of the learned conducting counsel for the petitioner seeking a genuine on ground of personal difficulty. The same not being objected to by the respondent. It is the said prayer is not objected to by the learned counsel for the respondent. The same is allowed. As prayed for, list this matter after 2 weeks.
Much obliged.
So that is 14 to 20.
Item number 21.
It is a small matter. It can be decided. Here, my lord, what happened? There was a post vacant in Mahendraganj Defence School, my lord. And there was no managing committee. The managing committee was before this honorable court, my lord, for issuing for settlement of some issue, my lord. On the meantime, my lord, the headmaster, who has no authority, has published an advertisement for filling up that post, my lord. And this honorable court, my lord, after on the motion stage, my lord, has stayed that, my lord. Now I was told that the managing committee is there, my lord. The direction may be given to, my lord, advertise the post by the managing committee, my lord. Only that is my prayer, my lord.
Who are you?
I am one of the managing committee member. That time I was holding the secretary post, my lord. I was before this honorable court at that point.
What is your prayer?
Lord, my prayer was to set aside the advertisement which has been issued by the headmaster, my lord, because the law doesn't permit him to issue the advertisement, my lord. My prayer is in page 36, my lord.
You are the managing committee.
I was the managing committee, but that time I was one of the members of the managing
and
committee.
The headmaster is, part of the managing committee.
No, my lord. That time there was no managing committee. That is why I was before this honorable court, because the managing committee, I was part of it, my lord. The government was not giving the approval because one of the president was the wife of an ex-chief minister, and a different party was probably here, my lord. That is why they was not approving, and they have not approved also, my lord. Till date they have not approved. They have formed a different managing committee. That is one of the sad part. But my lord, I am before this honorable court, my lord. I was the secretary of that elected managing committee, which was not approved. That the advertisement which was floated by the headmaster, he was not authorized, my lord, as per the law. It is the managing committee who is authorized as per the law, my lord.
You have made a headmaster party?
My lord?
Headmaster has been made a party?
Yes, my lord.
Is he here?
He has filed an affidavit, my lord. If I am not mistaken, he has filed an affidavit, but after that, my lord, he has disappeared, my lord.
No, but any ex parte order passed against him?
I will just find it out, my lord, because this matter is of 2019. I will just
I'm not.
see
I
the
don't
record.
think so.
What has the state got to do here?
My lord, state has already filed the affidavit. Question is, my lord, what will be the locus of the petition?
That is to be decided.
My lord, it may come up anytime next week.
What do you check, Mr. D? Check
I will just
on
check.
you see, whether the headmaster is.
Probably headmaster has not filed, my lord. I have been instructed. Probably the headmaster has not filed. Probably there is an ex parte order also. I brought into notice of the court. But let me check, my lord. I'm not very certain about that.
So we'll take it up on Thursday then.
This Thursday, my lord, I will be out of station. I have to attend. One of my uncle, he got paralyzed, so I have to go and visit him.
So 1 week
After a week, my lord. Tuesday, my lord. Can it be on Tuesday?
on premier by the learned counsel of the petitioner. This is matter of the 1 week.
Highly.
Item number 23.
Yes, have you? Who's
Lordship, I just actually my the petitioner is sick. I just prepare everything. Just will filing during the course of those additional affidavit.
you have to file the additional fee?
Yes, Lordship. I will file during the course of the day. Actually, on today only he has come for signature due to some difficulties. I think he said she was sick and all.
Additional affidavit on what issue, my lord?
No. Last time there was an order, and then even they suppose the private respondent also said that they will be filing some affidavit, but then they have not filed it.
Once they file lordship, accordingly we will file.
Yes, so there are two, I mean the two sides have made a prayer for filing of
Lordship. Both parties have not filed.
So both parties have not filed.
Not filed.
Once they file lordship,
Why?
accordingly.
You see, you have to file on your own. You are not
Yes,
to respond
Lordship.
to.
Yes. Lordship.
You have made a submission that you have, there are certain facts within your possession, or whatever records that are in your possession, which requires to be brought to the notice of this court by way of an affidavit.
Lordship.
That is to further your case. Similarly, the petitioner has also, has made a prayer that they may bring certain facts to the notice of this court or to the attention of this court.
The petitioner
After
is
1
seeking for,
week, 1 week times.
further inquiry investigation into the matter.
Yes, Lordship is aware, Lordship.
And the trial court has already accepted the FR.
Yes.
No, that is
So,
not the case.
being agreed by that, the petitioner has approached, and now the petitioner wants to bring an additional affidavit. Additional affidavit to the affidavit filed by the complainant, or additional affidavit to the original petition. That is what it needs to be clarified.
Let the
We'll file it because
then
the
this
already
court
passed
will
an
look-
order.
this court
At
will
that
look
point of
into-
time, you should have
No,
rejected.
it's not about that point of time. The point is that
Yeah,
on
we'll
what
file
issue-
it.
On what issue? they
Since
want
there
to
is
file.
already order that if there is then
Anyway, we'll look into this matter and see the legal implication of the actions of the parties.
yes, Lordship.
So whatever is relevant will be taken.
It's between the petitioner and private respondent actually. But they are the investigation officer. We have accused them also because that additional affidavit which I filed last time, I have made a submission that because we are accusing because there was a complaint against the conduct of the IO. We have said that there is a bias and unfairness, so we want to bring on the record on the additional affidavit. That was our submission.
Land counsel for the petitioner has submitted that he may be allowed to that the affidavit sought to be filed before this court today could not be filed, and some more time may be allowed for the same. Similarly, the petitioner or the land counsel for the respondent 5, 6 and 7 has also sought for some more time to file the additional affidavit. As prayed for, list the same is allowed. List this matter after 2 weeks.
Lordship. Much blessed, Lordship.
Item number 25.
Yes. Mr. Raman, you are in this case?
Our dream counsel Sashib here is also online.
Yes, Your Lordship, we are for the petitioner, Your Lordship.
You are for the petitioner?
Yes,
we both have.
So, Miss, you are supposed to take steps on the respondent 4.
My lord, we have taken step and we have filed the affidavit last Thursday. Same was placed on record. The notice has been received by the.
Mr. Raman, you are appearing for respondent?
No, my lord, but for the petitioner. For the petition.
You are for the petitioner.
Both. Yeah, yes, my lord. We both are from.
And Miss Priya, you are appearing for?
We both are for the petitioner, Your Lordship.
Oh, you're both for the petitioner. Okay.
Yes, Your Lordship.
Have you filed the affidavit of service? As regard the
Yes, ma'am.
respondent 4.
Yes, ma'am.
Or respondent 4 is the complainant. So what do? I think we'll wait for the respondent 4 to appear then.
Your Lordship, the petitioner is residing in Patna, Your Lordship, and it is not possible for her to come to Shillong on every date of trial, Your Lordship.
I think she's not getting it. So far, respondent 4 is concerned, my lord, is the complainant, is the vice chancellor of a university, Global Tech University, to the effect that an FIR was lodged by him, and the allegation is that another organization by the same name was floated in the net, inviting at questions, so on and so forth. So that FIR was being filed, and all the investigation has been done by the state. Now I think probably respondent no 4 won't be required, in my humble submission. I think it is the state who has to reply to whatever is there. So, and I will satisfy you also if they want to proceed with the case.
But then, it's like you say, if the respondent 4 is to be, presence is required.
That is I think affidavit has been filed.
Yes, they have filed. If he is a vice chancellor and having received notice, he should have appeared.
Exactly.
Since March, April, May. So what do? Should we wait for the respondent 4 to come?
Your Lordship, I have a prayer to make at this stage, Your Lordship. The petitioner is a lady, Your Lordship, and she has to come to Shillong on every date of trial, Your Lordship. So, Your Lordship, till at least the present proceeding is pending, stay should be granted, Your Lordship.
What is the
Your Lordship,
what is the stage of the case?
Your Lordship, charge sheet has been filed, Your Lordship.
Charge sheet has been filed.
Yes, Your Lordship.
Charges frame.
No, nothing further. Just the charge sheet has been filed.
No, Your Lordship.
Well, probably the fact remains that there are other co-accused to be arrested in this case. They have to be apprehended. Oh, that is my submission, however. But
Your Lordship, the only reason why petitioner has been roped in the present case is she is the wife of one of the co-accused. He was the person involved in that group and she is the wife. Her account was maintained by the husband, who is the co-accused in the present case, Your Lordship.
Of course, those are all matters of investigation.
Yes, Your Lordship.
We'll wait for the respondent 4 to appear then. Heard learned counsel for the
Your
petitioner.
Lordship,
Yes.
stay may be granted, Your Lordship. If
Fine. Heard learned counsel for the petitioner. Who has submitted that the notice issued upon the respondent 4 has since been confirmed, and to this extent an affidavit of service has been filed. However, till date the respondent 4 has failed to appear before this court. Mr. R. Guru, learned GA appearing for the state respondent, has submitted that the presence of the respondent 4 is important in as much as he is the one who has filed the initial FIR and therefore would be able to satisfy the court on the allegations made in this petition. Accordingly, for ends of justice, the respondent 4 is allowed to appear before this court on the next date fixed, as submitted by the learned counsel for the petitioner. Since the petitioner is a lady residing in Patna, for which it is not possible for her to come to Shillong on every date fix for the case before the trial court. Therefore, it is prayed that pending disposal of this instant petition,
If I may, Lordship. But so far the interim prayer is concerned, I have got a very serious objection. For the fact that it is not so simple, Lordship. What has happened here, the main kingpin is the husband of the petitioner, and throughout the entire episode, she was well aware of these facts. And Lordship, that not only that, subsequently what had happened was they were even wanted in the state of Bengal, and there were 3 FIRs against them. Their modus operandi was they were running a fake institute throughout the country, Lordship. So it is a case of huge economic offence where wife was very well aware about it, and her, Lordship, the saving accounts, it was used for.
Anyway, that you see, Mr. Guru, this court will not go into this aspect at this point of time. But as far as the proceedings is concerned, this court will just direct no coercive action to be taken against her. But
yes,
as and when, you see, if she is required, she has to be either virtually or otherwise.
About the stay, that is my
the proceeding will not be stayed. Proceeding will not. How can you stay?
Your Lordship, just one request, if required, if she may be permitted to appear through virtual mode, Your Lordship.
That is always there. That is always there. You see, nowadays, every court is functioning on hybrid mode.
Your Lordship, I am talking about the trial court, Your Lordship.
Even the trial court, even before the trial court, there is no. See, you can appear. You can always appear online anytime you are required to. So we have the the VC facilities in the trial court, so that you can do.
Yes.
If you are willing to do that, then there's no need for to stay the proceedings, as far as you are concerned. Anyway, we'll just say that of course steps to be taken. The proceeding before the trial court may be stayed. Next. On this aspect of the matter, the court has duly considered the same and has thought it fit that it would be improper to stay the proceedings before the trial court till this instant petition is disposed of. However, it is directed that no unnecessary coercive action be taken against the petitioner herein as far as the case against her is concerned. However, the petitioner is allowed to appear before the trial court or the investigating authority. Or the charge sheet has been filed, isn't it? To appear for the trial court
Yes.
through the virtual mode to answer to any query against her. It is only when it is absolutely necessary for her physical presence before the trial court is required, the trial court will pass these orders. You can do that. You appear virtual mode.
Yes, Your Lordship, obliged, Your Lordship.
What you can do, you find out the details, because that is available either online, or if you have a colleague here in Shillong, through your colleague you get the details of how to appear before the by virtual mode, and getting all those login details and everything, and once you get the link you can always appear as and when required. Even before the IO,
Yes,
but okay, the IO is no longer required here, so just between you and the court. Even if you are to answer to the charges, if charges are to be framed, you can always appear online. As
Yes,
per,
Your Lordship.
as per for this matter up to 3 weeks.
Obliged, Your Lordship.
You can call item number 7.
Your Lordship, the next date is on the 21st of June.
21st of June?
Yes. It's for calling the complainant to adduce his evidence as per the court information.
What is this case about, Mr. Chetty?
This case is about the petitioner had gone to work in near of the house of the victim. Then as time passed by, the petitioner, they have known to each other, and he had also proposed her. Then after that, after a long relation between them, the victim used to come to his house and used to